He received it. Bradley Bannon, one of the attorneys representing David Evans, took the 1,844 pages of underlying scientific data and started to study it. And he's not a DNA expert, but he went to school and he studied this paperwork and he tried to figure out what all this meant. But he didn't find the answer until after the general election. Mr. Nifong was elected DA. After the election, Mr. Bannon made it all the way through all this paper and figured it out. And he figured out that DSI had, in fact, found DNA from these multiple men who were not members of the lacrosse team and who were not any of the 3 men that Ms. Mangum admitted having sex with during the week leading up to this. So the defendants filed a motion. It was dated December the 13th. He detailed all of this. He said exculpatory evidence has not been turned over. When he received the motion, Mr. Nifong didn't pick up the phone and say, "I have made a horrible mistake. I assumed the information was in DSI's report. I didn't read the report, but I assumed it was in there. I'm so sorry. Let me get it to you right now." He didn't call up defense counsel and do anything. He didn't file a written response. He just showed up at the hearing. And at the hearing, there was first a meeting in chambers with the judge. And again, Mr. Nifong didn't say, "Gosh, I'm really sorry. There was a mistake. I thought it was in there." He didn't say anything like that. All he said was, that December the 13th motion was the first I've heard of it. No explanation of why it happened, no apology. Then there was a hearing in open court, and Mr. Bannon went through the entire process of the attempts to obtain discovery in this case and said exculpatory evidence was not turned over. Once again, Mr. Nifong did not say, "I am so sorry. This was an oversight. It was a mistake. It's a very serious matter. I believed that the evidence was in the report. I've got to get it to you." He didn't say anything like that. What he did was he offered Dr. Meehan, said, "Dr. Meehan, get up there and testify about what happened," and he did. Dr. Meehan testified that he discussed at the April 10th, April 21st, and May 12th meetings the results of all tests that were conducted by DSI to date, including the fact that there was the existence of DNA from multiple unidentified males on the rape kit items. He discussed, Dr. Meehan also testified that he discussed and agreed with Mr. Nifong that we would only disclose or show on our report those reference specimens that matched evidence items. Dr. Meehan testified that DSI's report did not set forth the results of all tests and examinations, but was limited to only some results. Dr. Meehan testified that the limited report was the result of an intentional limitation arrived at between him and Mr. Nifong not to report on the results of all examinations and tests that DSI performed. Dr. Meehan testified that the decision not to provide all test and examination results was based on privacy concerns. And Dr. Meehan testified that he would have prepared a report setting forth the results of all DSI's tests if Mr. Nifong had asked him to do that. And he would have done that after May the 12th when the initial report was done, but he was never asked to do so. Now, at the time this hearing happened, the State Bar had already sent a letter of notice to Mr. Nifong about his extrajudicial statements, asking him to address the concerns about those. After this hearing on December the 15th, where Dr. Meehan testified the way that he did, the State Bar sent a second letter of notice to Mr. Nifong, asking him to address the issues that had been raised in that hearing. After he received the State Bar's letter of notice, he sent an investigator from the DA's office to go interview Ms. Mangum. And Ms. Mangum changed her story in a whole lot of ways in response during that interview. In fact, she said that Reed Seligman didn't do anything to her at all. After that interview, Mr. Nifong dismissed the rape charges but kept the sexual offense and kidnapping charges in place, even against Mr. Seligman, whom Ms. Mangum now said didn't do anything to her. In his response to the State Bar's letter of notice, Mr. Nifong gave a lot of conflicting, varied explanations of what had happened. He said he didn't realize that the information wasn't in DSI's report because he was so busy with his political campaign, that he had turned over the responsibility for providing discovery to assistants and legal assistants in his office. He said he didn't turn it over because he viewed the information about the DNA from multiple unidentified male contributors as non-inculpatory as opposed to specifically exculpatory. He said that it was not included because of privacy concerns. He gave a whole host of different explanations. After the letter of notice was served on Mr. Nifong, he recused himself from the criminal cases and the Attorney General's office took over the investigation. After reviewing all of the evidence, the Attorney General's office dismissed the charges and declared that Mr. Seligman, Mr. Finnerty, and Mr. Evans were innocent. The State Bar has charged Mr. Nifong with many rule violations. from making extrajudicial statements that had a reasonable likelihood of heightening condemnation of the accused and had a reasonable likelihood of prejudicing an adjudicative proceeding, to concealing exculpatory evidence, failing to provide information he was required to provide in discovery, making false representations to the court and the counsel. Any one of these, standing alone or taken together, would be conduct prejudicial to the administration of justice. The conduct, in fact, did not just have a reasonable likelihood of heightening public condemnation, but in fact it did heighten public condemnation of the three accused. It did prejudice the administration of justice, not just likely to, it in fact did. The State Bar's evidence will demonstrate that Mr. Nifong intentionally sought out the world's attention, went on television, talked about this case. When the world was focused squarely on North Carolina and its justice system, Mr. Nifong repeatedly and intentionally misled the media and therefore the public about a very serious case, caused racial unrest in Durham, intentionally concealed evidence to which he now admits the defendants were entitled, but which was extremely harmful to his theory of the criminal case, and made false representations to two judges in an effort to keep the defendants from discovering it. The harm done to these three young men and their families and to the justice system in North Carolina is devastating. The public perception is that justice can't be had in North Carolina unless you know how to play the shell game. If you can figure out how to play the shell game, you might get justice. The public perception is that the justice system in North Carolina has no integrity. This didn't have to happen, and the horrible consequences were entirely foreseeable. Thank you.
Thank you.